Additions?
Yes, Mayor Borelman. Administration would like to add one in-camera item under L. An update on the negotiations with the MD of Bighorn on the Recreation Services Agreement.
Great, thanks very much. That I'll move the agenda be approved as amended. Those in favor? Oppose? Motion's carried unanimously. First order of business is the public hearing for the Land Use Bylaw Amendment 2020-17, revisions to Section 6.5 CW Conservation of Wildlands District. I know there's these two residents are here to speak directly to council, and I understand we had one or two written submissions. So I'll call to order the public hearing for Bylaw 2020-17. The purpose of the bylaw is to amend the land use bylaw by revising Section 6.5 CW Conservation of Wildlands District. The public hearing will proceed as follows. First, administration will provide an overview of the matter under consideration. Council will then have an opportunity to ask questions of administration. And after council question period is finished, I'll invite members of the public to speak. There will be an opportunity for council to ask questions of clarification after each speaker presents. Once anyone present who wishes to speak has done so, the municipal clerk will read into the record the names of anyone who had provided written submissions for today's hearing. And finally, before we adjourn, administration will be given an opportunity to provide closing comments. And with that, we'll move to administrative briefing. Mr. Gravel, thank you.
Thank you, Mayor Borman. Just allow me 1 second here to share my screen. Okay. Can everybody see the PowerPoint?
Yes.
Great. Okay, good morning, Mayor Borman, members of council. Bylaw 2020-17 proposes to reinstate 2 land uses in the CW Conservation of Wildlands District. These uses recognize existing development on specific sites developed prior to the approval of the 09-99 land use bylaw. As part of the recent land use bylaw update, administration considered these existing developments, for example, a quarry and a resort, to be out of alignment with the purpose of the CW district, and that given they were restricted to their respective sites, to remove them, making them legally non-conforming, was thought to better align with the intent of the district. However, the wording of the uses provided landowners with existing developments some opportunity for future expansion or to rebuild if there was a fire, but limits it to their respective sites. When these uses were removed, it left only public uses with no opportunity for development, which can be considered a de facto taking of land. This triggers Section 644 of the MGA, which I've included up on the slide. Within 6 months of making the change, the town must acquire the land or require the land to be provided as reserve land, commence proceedings to acquire the land or require the land to be provided as reserve land, and then acquire that land within a reasonable time. And finally, amend the land use bylaw to designate the land for another use or intended use. Administration obviously doesn't recommend the option A or B, given the significant capital costs required to acquire these lands. And also there's no plans by the town to use these lands for public purposes in the foreseeable future. Therefore, administration recommends option C, which is facilitated through this bylaw. Regarding public comments, concern was raised by Bookward with respect to the removal of the 2 regulations from the CW district noted up on the screen. These include development permit applications shall demonstrate to the satisfaction of the development authority that the proposed development or expansion to the existing development will not detract from the quality of the natural values of the area surrounding the proposed development expansion. And the other operating and progressive reclamation plan shall be required as part of the development permit application requirement for the surface expansion of any existing quarrying operations, such being a type of development approved prior to third reading of Bylaw 0999. These were removed at the same time as the uses in question were removed. These regulations only applied to the existing developments, so it was no longer necessary to keep them in the district. We did look at reinstating these uses. However, with regards to Clause A, we identified that this clause was somewhat redundant. The uses are discretionary, so administration already has the authority to require what's noted in the clause, as well as any other information that we deem necessary as part of a development permit application. With regards to Clause B, reclamation work is governed by the province. Therefore, while we could require a report to be submitted, we would have no authority to require more or less than what the province would have already approved in the plan. Again, because the use is discretionary, administration already has the authority to request the reports, the studies, and additional information to help make a decision on the matter. So these were reviewed, but it was determined they weren't necessary to, it wasn't necessary to put them back in the bylaw.
Do you mind if I interrupt here,
Sure.
Mr. Gravel? So I'm not that familiar with the process, the provincial process. Could you, I know we've talked about it in the past, but remind me how that would work if the owner was interested in expanding the quarry operations. It would be an exercise done entirely with the province of Alberta. Is that how it works?
They would need to show that they've got approval from the province in order to get a development permit to expand the site. So they'd have to work with the province, similar to if you were to want to add a gondola to the community, you'd have to go to the province and work with them to get those approvals first. And then we would require that as part of your development permit application, look at what the province has stated the required mitigations are and so forth, and just ensure that your plan reflects that.
So once the province has given their approval, then what are the rights or opportunities of the municipality?
I think when it comes to the surface works, et cetera, I don't think we have much rights. I think when it comes to the design elements of the site and the building and those sorts of pieces, we would have more influence and say on percentage of the site to be landscaped, where the building's located, what it looks like in terms of materials, how high, where the access is, those sorts of details would be where the municipality would get involved.
Right, and because this is a discretionary, or would be a discretionary use, the town has the ability to exercise discretion in those areas that we actually do control.
That's correct. You can require any information you need, or you could refuse an application if it's discretionary based on either you're not satisfied with the information provided or the design of something because it, for example, doesn't meet good planning practices, or it doesn't meet the guiding documents of the municipality. So there's quite a lot of discretion there for the development authority to work with when we receive an application for discretionary use.
Great, thanks for those additional comments.
You're welcome. We also received a question about what accessory uses are, as one of the uses to be reinstated speaks to accessory uses approved prior to third reading of the 0999 land use bylaw. Accessory uses are subordinate, incidental, but directly related to the principal use of the premise, building, site. That's the definition, if you will. An example in layman's terms would be a kitchen within a hotel, or a valet service at a hotel, things that are accessory but related. They're not really something the public would take advantage of. They're not driving any type of additional visitation per se. They're just supporting the principal use. So should any landowner wish to expand an existing accessory use, they would need to apply for a development permit. It's considered discretionary use, and there would be opportunity for public comment, and any decision would be appealable. So that concludes my presentation for the public hearing. Happy to take any questions council may have.
Thank you very much. Are there questions from members of council for Mr. Gravel? Councillor Sanford?
Thank you, Mayor Borman. Mr. Gravel, I just wanted to confirm that any new development would, you said it would be discretionary, but that the regulations would be applicable of the minimum setback would be 15 meters
Yes, that's correct, ma'am.
off the edge of the property. And then the maximum height of the building would be 10 meters.
That's correct.
So this would apply to anything that occurred in this particular land,
Any new development.
in this area. And then there's a clause in the MDP that's also referred to here, 4.2.10, where expansion of development footprint or intensification of an existing use within a wildlife corridor or habitat patch is considered, the town will require an EIS to be prepared.
That's correct. They would also
So
require to
Okay.
complete an environmental impact statement, and we would look for to that report to see what the required mitigations are to ensure proper protection of wildlife.
And this would be part of your discretionary decision. based
That
on-
wouldn't, that would feed into the decision-making process, but that would be a requirement that they would have to abide by. So there would be no discretion in whether or not they would provide the EIS. That would be mandatory based on what the MDP says.
Yeah, okay, I understand that. This is a mandatory requirement, but the decision is still discretionary based on all the information that you require or you get.
That's correct. However, the decision is appealable should somebody believe that the information wasn't properly accounted for or considered.
Would there have to be public hearings involved in the process?
No, the decision would be appealable. So it would go to the Subdivision and Development Appeal Board. So I guess that would be like a public hearing, if you will. Residents could, or anyone who's an affected property owner could go and state their case, how they are affected to the board, and the board would then consider the matter and the information provided. So there
So
would
it
be an
would-
opportunity, sorry.
You would post a sign on the property saying this has been approved, and then people could weigh in after that.
So it would be, a notice would be posted on site indicating that a decision has been made to approve the development, but it would also be posted in the newspaper. So those who don't drive by or walk by or bike by, the site would still be able to receive some notification of that. I imagine, you know, if there was to be an expansion of any of those existing uses, that we would likely have it up on our website as well and notifying people.
Okay, thank you.
There are other questions from members of council for Mr. Gravel? Seeing none, thank you very much, sir.
Thank
Now this brings us to public submissions. And of course, as always, council would like to hear from everyone who wishes to speak. I understand there's 2 speakers registered. In the usual spirit of public hearings, we'll be enforcing a 5-minute time limit on presentations, which wouldn't include the time for questions from council. And there'll be a countdown timer to help us stay on track. And if you are speaking, you should be aware that you'll appear on the live web stream of this hearing, and that a recording of the web stream is published online. And while you are speaking, we ask that you direct your comments to council and limit your comments to the subject of the public hearing. Council will be given an opportunity to ask questions of clarification after each presenter has finished speaking. We ask that speakers and members of the gallery join council in supporting the rights of everyone to be treated with dignity, fairness, and respect. As chair, I will intervene if necessary to uphold these principles. Now I'll open the floor to speakers, and I guess we'll go alphabetically. Since there's only two, that seems reasonable. So if I'm not mistaken, Mr. De Keyser, yes, he's in the waiting room there. So we'll open the mic for Mr. De Keyser. Sir, how are you doing? You're muted. You gotta open your mic. You gotta turn on your mic, Steve.
Okay, thank you.
There you go.
All right.
I know this modern
This old
technology.
retired guy, my production values are pretty low. Okay. So I registered as opposed to this bylaw, not because of what's in it, but something that was left out. Mr. Gravel has already addressed that point. So this bylaw brings back the opportunities for development and extending existing development. However, it does not bring back the requirement for reclamation. The requirement for reclamation, ongoing reclamation, was taken out the land use bylaw as well. It's in my written submission, section 5644. And to the best of my understanding and discussion with administration over the last 6 or 7 years, ongoing reclamation has in fact not been going on. And I would respectfully disagree with Mr. Gravel. I think that while it's the province's responsibility to ensure reclamation is done to their standard for a quarry, just like wildlife is a provincial responsibility, the town has a real interest in this. It's zoned conservation wildlands because the long-term purpose is to reclaim it, not like Quarry Lake for recreation or like the strip mine or meadow at the Nordic Center, but as part of the wildlife corridor area for Boone Valley and across the valley. Back in 2015, council went to the municipal government board to challenge the MD Bighorn's proposal for their development outside of Dead Man's Flats because it would interfere with those wildlife corridors and wildland conservation areas. So I think, to get back to the point about the reclamation, I think it's important. I know that now the reclamation requirement is in just general regulations section of the land use bylaw, but there's only one quarry in town. I doubt that there are going to be any others. We all know Three Sisters has submitted an area structure plan, which includes the quarry, even though it's zoned wildland conservation. I think it's important for council and the public to be aware that the current zoning is wildland conservation. Sorry, I'm not up to date. Conservation of wildlands, CW. And also that there's a reclamation requirement. Council has the authority to change those zonings and to allow development. But right now, those requirements are there. And I think they should be put back up front in the land use district. It is the only quarry in town, and it is important to have that as a visible reminder for all of us that that is the long-term intent. I think that's it.
Thanks very much, sir. Are there questions from members of council for Mr. De Keyser? And certainly, administration will be given an opportunity to provide closing comments, and perhaps we'll hear from administration on that specific point.
Sure.
Just to clarify. Hmm?
Do I have any more time?
I haven't heard the beeper.
Okay.
Keep going.
Zoom, to me, I'm sure that it's legally qualifies as a public hearing. But to me, one of the council's strategic goals in your strategic plan from, where's my notes, 2019 to 2022 is to meaningfully engage with citizens for effective decision-making. And I'm sure it's a challenge for you too, but a Zoom meeting for a major complicated area structure plan or something, that's going to be tough. And as I say, I know it's tough for you too, but something that affects the town for, I mean, this is a pretty simple bylaw, pretty simple to make a submission. Much more complex. It would be a challenge. Thank you for
Yeah,
your time.
don't disagree with that. And I don't know how things might change between now and when there may be public hearings scheduled for the area structure plans.
We might have a new prime minister, the states might have a new president, all kinds of things.
Yeah, the universe is unfolding. I don't know if it's as it should, but the universe is unfolding. We'll certainly be using the best technology available and or public presence, if possible, when we get to those public hearings.
Sure. Yeah, I just wanted to throw that out.
Okay, thanks. No questions from members of council? Then thanks for appearing, Mr. DeKaiser, and I'll ask then that Mr. McFadden take the mic.
Good morning,
Morning.
councillors. I'm making a presentation on behalf of BOCORD, BOCORD, or Organization for Responsible Development. And I was somewhat surprised to hear Mr. Gravel's comments on our presentation before I'd had a chance to make it. He has already set out the main suggestions that BOCORD is making, and it seems to BOCORD that these suggestions, proposals we're making relate very directly to the matter of the bylaw. The bylaw proposal, which we fully support, and are glad that council and administration picked up on this point before it involved any significant cost to the public. But the bylaw essentially puts back into the land use bylaw several proposals, several provisions which allow for further development. What is not transferred, as Mr. Gravel said, were the two precautionary elements of the land use bylaw back in 1999, which emphasized the conservation elements associated with these development proposals. And BOCORD feels that it's very important that the land use bylaw should explicitly include these provisions which are protective of wildlife, as well as the provisions that make room for further development. The two provisions relate to development permit applications, as Mr. Gravel showed, and the ones that Steve DeKaiser just spoke about. And we fully support what Steve said on the second one. It seems to us that Canmore has a right and responsibility to hold provisions regarding reclamation very strongly, and that this should be recognized in the land use bylaw, and it should be recognized in the section of the land use bylaw that deals directly with the CW zoning. We would make the same argument with respect to the first provision. This was included in the 1999 land use bylaw. It went along with the two uses which are being reinstated now in the 2018 land use bylaw. And it made clear to anyone looking at the bylaw that there were precautionary elements associated with these developments, as well as the legal authority to undertake them. It may be that in some sense, these provisions would be redundant, in that if one reads the entire land use bylaw, you can see that provisions regarding development in these areas are covered. However, in the 1999 land use bylaw, these provisions were included directly in the section that allowed for the development. It therefore made crystal clear that there were precautionary principles regarding development in these areas. One didn't have to understand or go through the whole land use bylaw in order to see it. To suggest they should not be included now because there's some redundancy doesn't seem to BOCORD to make a great deal of sense. We understand that one does not want the land use bylaw to be redundant and longer than it has to be. However, I think it's very important that the provisions of the land use bylaw, the sections that people have access to, make very clear both what development is allowed and what restrictions have to be met before development can take place. The 1999 land use bylaw did this. If council moved to incorporate these two provisions from the 1999 land use bylaw into the 2018 land use bylaw in the same way in which they were done in 1999, I think it would be a vast improvement and would recognize both development aspects of proposals on these lands that were zoned prior to 1999, but also the conservation and wildlife concerns that have to be met as well. So I hope that council will look at our proposal seriously and will move to transfer these precautionary elements into the land use bylaw as well. Thanks for your time.
Thank you very much, Mr. McFadden. Are there questions from members of council for Mr. McFadden? Seeing none, thanks very much for being here to speak today. At this time, I'll ask the municipal clerk to read into the record the names of anyone who has provided written submissions during today's hearing.
Thank you, Mayor Borman. Record of public submissions was published on Friday, September 18th. It contained one submission from Marjorie Bridge. Also, our two speakers today, Steve DeKaiser and Alan McFadden, on behalf of Beaucord, have submitted written submissions as well that will be added to the record.
Thanks very much. And now we have an opportunity for administration to provide closing comments. Mr. Gravel.
Thank you, Mayor Borman. I just want to thank the two gentlemen that spoke and provided their comments. Administration can certainly appreciate the desire to have some additional clarity within the district on some of the requirements. Certainly that wouldn't conflict with anything in the bylaw. Administration certainly doesn't have any concerns if council wish to add that back as an extra piece of transparency and a reminder to any development authority that that's emphasized in this
You're
district.
speaking specifically of 6.5.3.4, which was quoted in relation to reclamation plans.
Yeah, both. I think both would be fine to add back. As I mentioned, we did feel it was a bit of redundancy, but certainly we've heard that there's a great concern with ensuring that that these are in there so that there's an expectation that the public could be aware that these are requirements. And so there's maybe a greater transparency there. And so we don't have any addition or a concern, pardon me, if they were to be added back.
Okay, thanks very much for those comments. Are there any questions for Mr. Gravel from the council? Councillor Sanford.
Thank you, Mayor Borman. Mr. Gravel, I'm curious about the concept of ongoing reclamation, because I would imagine a reclamation process taking place once a development or once a quarry is exhausted, and then you're going to transition it into something else. So the concept of ongoing reclamation, can you speak to that at all?
I'm no expert in ongoing reclamation. I think the intent here is that as you expand, you return where you've been back to the condition that it was previously, back to its natural features. That's something that would likely form part of a condition of approval for a development, should it be approved. So if they wanted to expand, as you would usually get conditions for approval, and we typically say, you have to do this with your development, this amount of landscaping, that sort of thing, and that would form a part of it. You need to, reclamate the land that you're no longer working on.
So are we seeing that happening? Ongoing.
Uh,
I'm
That
not too sure. Sorry if I could interrupt. Councillor Sanford, I'm not sure this is directly relevant to the matter at hand. I mean, it's related, but it's not affecting the decision council's going to be asked to make today, unless I'm missing where you're going with this.
Well, I'm just raising it because it was raised at the public hearing, and I'm not really certain from a planning perspective what the process is for reclamation. It's a process, right?
Sure.
So is it something that happens at the end, or is it something that happens throughout the process of when the landscape is used? Is it supposed to be reclaimed right away, or is it supposed to be reclaimed at the end? I'm kind of thinking about in terms of like the landfill. You reclaim it when you've exhausted the resource. But it's not an ongoing reclamation kind of process.
That's a great question, Councillor Sanford. I'd need to look into the conditions of approval for the quarry to understand what their requirements are. I imagine it's specific to each development, how the reclamation would work, when it would occur, how long it would take, what the state it needs to be returned in would be. So I don't know as if there's a perfect answer to your question, other than reclamation would be required as part of future development. It'd be a condition of approval, and we'd be able to enforce that work.
And since it's a discretionary process, you would be looking at that as one of the elements of any further approvals.
Absolutely.
And you said that you don't see any problem with reintroducing those two clauses into the land use bylaw that were just raised?
No, as I mentioned, we didn't feel it was entirely necessary to put them back because it was, oh, I see Ms. Miller would like to jump in here.
Ms. Miller, the mic's yours.
Thank you. So we have heard the comments that have been brought forward by the public. And so if there was a desire by council to reinstate those clauses, we would, you would have the right to make that motion. But at this time, the bylaw, as we proposed, is the administration's recommendation on how to move forward.
Thank you. Thanks
Thank you.
very much. We're good, Councillor Sanford?
Thank you, yes.
If there's no other questions for administration, we'll move on, and I'll close the public hearing. Thanks all. And as it happens, the next order of business on the agenda is item G1, the Land Use Bylaw Amendment 2020-17, revisions to section 6.5 CW Conservation of Wildlands District. And so we'll be moving directly into that business. There is a report attached to the agenda, and Mr. Gravel, did you want to speak to your report?
No, sir.
Okay. Are there any further questions specific to the report under G1? Seeing none, I will move right into the motions then. This time I'll move the council give second reading to bylaw 2020-17, the revisions to section 6.5 CW Conservation of Wildlands District. And I will move an amending motion to also amend the bylaw with new wording to reflect the two issues that were raised at the public hearing, the 6.5.3.3 development permit application shall demonstrate to the satisfaction of the development authority that the proposed development or expansion to the existing development will not detract from the quality of the natural values of the area surrounding the proposed development expansion, And the second addition, which would be, as noted in the submission, 6.5.3.4, operating and progressive reclamation plans shall be required as part of the development permit application requirement for the surface expansion of any existing quarrying operations, such being a type of development approved prior to third reading of bylaw 0999. So amending motion is on the table to bring those two sections of the 0999 land use bylaw to be reflected in the current bylaw. And in speaking of the motion, I fully appreciate our intent when we developed the new land use bylaw, that we were trying to consolidate and make the bylaw more readable, remove a number of redundancies and sections of the old land use bylaw that were no longer fully necessary. But clearly, these two sections have meaning and importance to members of the public. And I feel that they're a perfectly reasonable additional direction to have within the land use bylaw. So I'll support that amendment. Others speaking to the amendment, Councillor McCallum.
Thank you, Mayor Barman. I too would be happy to support your amendment. I do also appreciate that when we came up with the new land use bylaw that we were amending a 20-year-old document, and that we were trying to strip a lot of the redundancies and repetitiveness and make it a lot more user-friendly. Because these are motions, the second motion specific to reclamation, which I don't think actually a lot of people have put a lot of thought into publicly as to what happens at the end of the quarry's life. But specific to reclamation, and that it provides a level of comfort to those members of the public that this is important to, I would be happy to support this.
The councillors wishing to speak to the amending motion? Councillor Sanford.
Yes, I too will support those amendments. I think it is important to consider that a conservation area should be reclaimed, because you want it to go back to the original use that was intended, which was the support of the wildlife. So if these two clauses bring it closer to that alignment, it also helps the overall function of that section of the bylaw. So I will support those amendments. Thank you.
The councillors wishing to speak to the amending motion? Seeing none, I'll call the question on the amendment. Those in favor? Opposed? Motion's carried unanimously. Back then to the second reading of the bylaw as amended. So is there discussion on second reading of the bylaw as amended? I'll speak in support of second reading. This is initially, it seemed like a straightforward and relatively obvious initiative or request that came forward to council from admin, recognizing that in the very complex work that was done to revise the old land use bylaw, there was an oversight in removing some of the text within the CW district in regards to permitted and discretionary uses. So I think it's really important that the town, when things come to our attention, errors that may have been made in the past, that we do our best to correct those errors. We've done this in the past. It's a part of good governance. And I appreciate that this has come forward for council's decision, and I'll be quite happy to support the motion. Further discussion on the motion to give second reading? Seeing none, I'll call the question. Those in favor? Opposed, motion's carried unanimously. And then I'll move the council give third reading, bylaw 2020-17, revisions to section 6.5 CW Conservation of Wildland Districts. Discussion on that motion. Councillor Sanford.
Thank you, Mayor Borman. I will support third reading at this time. And I think administration did outline that these changes are discretionary. These uses are discretionary, and bringing those clauses back into the land use bylaw will correct some unintended consequences. I think if we have to reinstate those, the unintended consequences can be mitigated. The other thing is that this section of the bylaw is appealable, and there will be notice to the public if anything changes. And also that the MDP requires an EIS to be produced to have any of these changes enacted. So I think there's a lot of strength in the layers of oversight on this. So I think it's a good time to approve second or third reading. So I will be happy to do that.
Further discussion on the motion? Seeing none, I'll call the question. Those in favor? Opposed, motion's carried unanimously. The only other item on the agenda today is in camera. So, so I will move that council go in camera to protect information related to the town's contractual negotiations in accordance with section 25(1)(c)(3) of the FOIP Act. Call the question. Those in favor? We're in camera.